What's up, y'all? It's your girl J Renee with Prison Ride Radio. I hope that you're doing well. This afternoon, we got brother Basil back, all right, aka Donell J. Blount Sr., and he's going to talk to us more about some cases out of Virginia, all right? This is a particular one that you definitely want to pay attention to because it's definitely got a few plots and twists. Hey, bro, you there?
Yes, I'm here.
All right.
How are you this afternoon?
I'm doing all right. I appreciate you being able to make it back to us to talk to us more about some of these cases that you come across in Virginia.
Absolutely. The platform that you give us is such a tremendous blessing because, having an ability to get the word out to the public about what goes on with some of these cases, it is imperative in this fight for prison justice reform and criminal justice reform. As we know, if you walk down the street and you ask someone about a particular guy's case, they're looking at you like, who? So unless it receives national media coverage or a celebrity got involved, it's very unlikely that people are going to know about particular situations or particular cases out here in Virginia. And as I said earlier, I don't just take a guy's case and publicize it unless they can show me by a preponderance of the evidence that they can survive the scrutiny that I subject their claims to. And when you're in here, you start behind the 8 ball. So you've already been convicted. Your appeals have been exhausted. You've probably gone through your habeas corpus process, and you've been denied. So by the time you come to talk to me, you're at the end of your ropes. Right. So my thing is, well, if you lost this many times, why should I believe that you should have won? And I require guys to show me why. And what happens a lot of times is that guys will have a valid legal claim. They will have a valid factual claim, but they lack the sophistication in order to properly submit their claims before a court. And that oftentimes leads to statute of limitations expiring, and brothers aren't able to get their cases to a court in such a fashion as to obtain release that they are clearly entitled to. Case in point, one of my brothers here, Anthony Boone, a.k.a. Rashid. Rashid case is out of Suffolk, Virginia. This case was an incident in where an individual said he was the victim, said he was laying in bed, and two people broke into his home, accosted him, stabbed him in his hand, pistol with him, and then shot at him with a AK-47, striking him several times before he jumped out of the same window that the assailants had come in through. I have a statement here, and you would think that once this statement was given, the case would have come to a conclusion, or at least they would have tried to find another way to find out who did this versus using the victim's testimony as a way to identify the suspect. This case, the incident happened on 5/29/2007. On that date, Detective C. Brent from the Suffolk Police Department said, "Sir, on 5/29/2007, I responded to 320 North 4th Street to assist Officer X. Fowl, who was out with a shooting victim. The victim was identified as, I'm going to leave the victims off the air here because he was obviously victimized. The only question is, who did it? I asked I'll just use his last name. I asked Mr. Wilkins who shot him. Mr. Wilkins replied, quote, I don't know. They had masks on, close quote. As you just saw, the night of this incident, the officer that responded to the scene said that the victim told him he did not know who shot him. They had masks on. He went on to tell them, like I said, the people came to the window. The crime scene techs came to the scene, and as we all know, they did their job. They did their due diligence to obtain evidence to find out who the culprits were. The problem is that during Rashid's criminal proceedings, because here's what happened. Eventually, it came out that Rashid was supposed to have been the guy that broke in this guy's house, or one of the people that broke in this guy's house and shot him. So it turned out that the victim was questioned by a Detective C.M. Gonzalez. According to Detective Gonzalez, he went and interviewed the victim for the first time in September of 2007. And at that time, the victim told him that Rashid was the one that had shot him. So he said that based on that, he went to obtain a search warrant. An arrest warrant, and had Rashid arrested for this case. This is how Rashid came about. Name came in this case. Now, during the course of trial, Rashid filed a motion for discovery, asking for any evidence that would exonerate him or that would tend to show that he was not the perpetrator of this crime. He's always maintained his innocence. Rashid had a great job back then. He was a brick mason, and I'm talking about the brothers making $20-some an hour, a full-time job. Great benefits, overtime, married with children, a family man. When prior to trial, when he filed for discovery, he was told that there was no evidence, and I'm going to read this right here. Here you are. This is from May 29, 2007. This is from Joanne R. Jones, Forensic Unit Supervisor. She said that she had been called to the scene. This technician responded to the scene to assist Technician Harrison. Upon my arrival, Technician and Detective Gonzalez advised me the scenario of the crime scene. I was advised that the victim was approached by two males within the home and shot several times while trying to flee through a bedroom window. She goes on to say, second page of the report, she says here, there was no evidence recovered. However, myself and Technician Hasty went across the street behind 320 North 4th Street and began looking for any evidence because of a Ricky O'Roy's van being shot through twice sitting in front of the house. On the driver's side of the street. These shots were possibly fired from the victim's location. While searching for any cases, I noted a burgundy-colored piece of material, and Mr. Miles picked it up immediately and said this was not here on yesterday in my yard. I then placed it within a brown envelope as evidence. I began thinking I had seen a burgundy-colored sheet somewhere else and knocked on the door of the victim's location. I asked to come in and retrieve the burgundy sheet from the bedroom of the broken window where the cases were found on the floor. This item was also placed in a paper bag and sealed, and both items were given to Technician Harrison because of her being lead technician on this case. Now, during the entire case, the entire course of Rashid's trial, they claimed that there was no evidence collected. So, the victim submitted a sworn affidavit stating that, contrary to Detective Gonzalez stating that he told him Rashid was the one that shot him, he said he did not. And that if anyone thought that he did, he was recanting his testimony and said that Rashid was not the shooter, that he did not know who shot him. At which point, the Suffolk Police Department arrested the victim and told him that he was being held as a material witness in the case. And it was threatening to charge him with perjury for saying that Rashid was not the guy that shot him. And remember this, the guy, the very night that this happened, he said the guy, people that shot him had masks on, so he don't know who did it. Eventually, he would come to trial and testify and change his mind and say that Rashid was the guy and that he had in fact been arrested and threatened by police with perjury charges and further incarceration if he did not come and testify against Rashid. Now, that was in 2007. Excuse me 1 second here. Make sure I said the document right here in front of me. Yes, that was 2007. Now, Rashid was eventually given 20 years. I'm sorry, he was given 45 years and a $40,000 in fines. In pursuit of evidence to prove his innocence, Rashid was actually able to find that he wrote the forensic unit. He filed a motion in the circuit court asking them to preserve any evidence in this case that may not have been tested. So the district attorney in Suffolk adamantly opposed his motion. The judge granted the motion and denied the motion and would not allow Rashid to have any untested evidence preserved or tested. How he figured to do this is kind of beyond me, because I would not have thought to do this, because by law in Virginia, you're not entitled to forensic evidence unless it's ordered by the court. So Rashid, in 2016, 11 years after his case, Rashid persistently wrote the Department of Forensic Science. On November the 2nd, 2016, they responded to his letter, and this is by Mrs. Amy M. Curtis, Department Counsel. Dear Mr. Boone, your letter to the Department of Forensic Science requesting information regarding the above reference file was received in this office. Pursuant to Virginia Code 2.2-3703, the Freedom of Information Act does not, quote, afford any rights to any person incarcerated in a state, local, or federal correctional facility, close quote. Nonetheless, the department has elected to provide you with the enclosed certificate of analysis dated September 28, 2007 and October 10, 2007, issued as a result of the examination performed by the Department of Forensic Science. So they sent this to him. And showed me this. This is what really got me on Rashid's side. Now, remember that the evidence technician claimed that she did not collect any evidence from the house. Well, contrary to her claim, there were Basil swabs taken from the window sill where the person touched coming through the window that broke into the house. There was that piece of burgundy sheet that she found in the other person's yard that she claimed that they took the sheet off of the bed that matched it. Well, it says here that, and that item is listed as number 5, and then the torn sheet is listed as number 20. And it says, no blood was observed on the swab from the window sill or the piece of sheet. DNA profiles consistent with each other were developed from the swabs from the window sill and the piece of sheet. And it goes on to say that Lamont Harris cannot be eliminated as a contributor to this DNA profile. Gary Karan Wilkins, Jalen Skinner, and Charlene Askew are eliminated as the contributors. Those are people that live in the house. An additional DNA type developed from the swabs from the window sill and 2 additional DNA types developed from the piece of sheet are not suitable for comparison. Searching against the Virginia DNA database bank or submission to the National DNA database. They had these evidence, these DNA swabs from that piece of sheet and from the window sill that matched the same person that did not live in this house. They do not match to Rashid. So for 11 years they kept this evidence here. And this, remind you them, they had this evidence on October the 10th, 2007, before he went to trial. So having this evidence in their possession, they elected not to turn it over to him. So this evidence would have gone on to bolster the fact that A, he did not come to that window. B, when the victim said the person that he could not identify the person, he was correct. C, the officer knew that they had evidence that pointed to someone else, and they have never to this day pursued that lead. So then we have that. When this case first went to trial, Rashid, there was a hung jury. The jury was composed of 6 blacks and 6 whites. The jury hung. The evidence in this case is, as we can all imagine, when someone tells us something happened to them, say we empathize with them, it happened. Now, when someone begins to tell a different story as to who did it, they say, okay, well, the person had a mask on. Okay, well, it was this guy. Okay, well, no, it wasn't that guy. I take my story back. Okay, well, yeah, it was that guy. We tend to stop believing them. Well, Rashid is a Muslim, and he had dreadlocks during the course of this case. One of the things that the prosecutor tried to play on was him being a Muslim, him having dreadlocks, him being radical, and according to the victim, he had an AK-47, and painting him as a terrorist. It did not work with his first jury. He got a second bite at the apple. During the second bite of the apple, he composed a jury. Utterly contrary and illegal is contrary to Basil versus Kentucky, which prohibits eliminating a members of the jury based on their racial profile alone. Now, the second jury had a good jury pool, but by the time they selected the petite jury to sit, the prosecutor had eliminated all jury members except for 2 blacks. So the second jury was composed of 10 whites and 2 blacks. And we can already see what this is going to. Yes, they found him guilty. Now, during the jury selection process, each side is given 4 challenges, 4 strikes of the jury member. They don't have to give an explanation. But when those strikes are utilized, and a pattern is showing racial profiling here, the Commonwealth has to explain why they struck a particular jury. For a reason unbeknownst to me, and how the judge allowed this to go on is criminal. The prosecutor said things like, oh, well, one of the jurors indicated that her husband was in trouble before, but she had no ill feeling towards the Commonwealth Attorney's Office. So she took an oath which indicated that she could sit as a fair and impartial judge of the facts. Another victim said that another juror the prosecutor struck, he said, oh, well, she lived too close to the incident. Now, please tell me how a person living too close to the incident would be beneficial to the defendant. If you're out there with AK-47 breaking into people's houses, shooting them through the windows, coming to their houses and shooting them, calling them to dive off their windows, you would think that a person living close to the incident would want you off the streets. Again, with no other reason than that she supposedly lived close to the victim, to the incident, which she didn't. And this lady expressed that She did not know any of the witnesses. She had never heard of Mr. Boone. She had never heard of the incident itself. So and this is the same thing with all the witnesses that they claim lived too close. So regarding their demographics or where they live, there was nothing that these jurors had done that would disqualify them as jurors. But it did serve the prosecutor's purpose of having a racially imbalanced jury. In a society that is majority Christians, or in a community, in a city that are majority Christians, and you have an individual who is being accused of having things like AK-47s, we can imagine what the 9/11 attacks have done to the psyche in America. You take an individual and you paint them as being radicalized. And this is how you go about obtaining conviction. So now you bring the evidence from the first trial, but you get a different way to present it. So now the witnesses are able to talk with more forcefulness, as in they had that the fact that they are now presenting to the jury, or the testimony they are now presenting is truthful. They've had time to compose themselves. They've had time to ask the questions that weren't asked before, or to correct the answers that were given in such a way as to ensure a conviction. So right now, Rashid, he has a habeas corpus petition out here. He has a writ of hate. He has a clemency petition currently pending before the governor's office. Now, there are a lot of people out here in Virginia that say that the current governor would not give clemency because he's a Republican. I disagree, and here is why. The lieutenant governor has been considered tough on crime, but what people don't know is that our lieutenant governor out here has actually had prison programs in which he has come into the prison with programs and making sure that people are doing the right thing for themselves to make the proper transition back in the free society. And she believes in giving second chances to those who carry themselves like that. While she has maintained jobs, he has gone charge-free for many, many years, and he has done the thing to come home. So even outside of his case, the way he has conducted himself and educated himself, matter of fact, he's over in brick masonry class right now.
You have 1 minute remaining.
So please call in, send letters in to the Governor Glenn Youngkin and Chadwick Dotson, the chairman of the Virginia Parole Board, and call upon them to grant mercy to Rashid, to either overturn this case and give him an absolute pardon, or to give him a conditional pardon and let him come home. I thank you all for your time and attention to this matter, and I look forward to bringing you more information as it develops with this and any other cases I'm handling going forward.